May I please report, Your Honor?
Yes, sir.
Your Honor, before you is Benjamin Bolton. He's currently charged with criminal sexual conduct in the third degree on warrant number 2001-21A45-10100441. He is represented by Charles David Barr of the Williamsburg County Bar. We're here today to continue the hearing that we started on Monday of this week. This is Mr. Barr's motion to set bond. It's my understanding that the materials from probation that the court requested to be provided to Mr. Barr have been provided to him, and we're now ready to proceed.
All right. Mr. Wilson, what did you come up with?
Judge, the information Mr. Barr requested, I gave it to him. The forms that Mr. Bolton signed, advised him of his conditions, the things he could and could not do. If the court would like to see those, I have a copy of those here as well.
Highlight what they're saying.
That is just a notice of registry form. He would need to register with the sheriff's office and that one.
Judge, I'm sorry, I can't hear you. Can you speak a little? I can't hear you.
The other form requires that he follow certain conditions for the offense that he committed, and each form was signed individually by him. That first form was signed at the institution prior to him being released. The other forms were signed in the office. Basic information on the notice form is just what would happen if he fails to register. The other forms.
I will not have any contact with a person under the age of 18, with the exception of my immediate family members, and then may only have such contact if approved in advance on the conditions set by my treatment provider and my agent. If I have incidental contact with any child, I will be civil and courteous and immediately remove myself from the situation. I will discuss the contact at my next treatment session. I will not enter, loiter, or work within 1,000 feet of any area or event frequented by people under the age of 18, including but not limited to schools, daycare centers, playgrounds, arcades, malls, festivals, theaters, unless approved in advance by my agent. Not consume alcohol, etc. All right, Mr. Barr.
Well, Judge, Mr. Wilson did present me with the documents that he just handed you, and I did review all of those documents. I just, in terms of addressing them specifically, first of all, if the prosecution, that is parole board in this case, decides to initiate an action against the defendant for violation of parole, I would submit that that's a separate matter. And of course, we would be prepared to defend it based on the factual allegations as we understand that they have occurred. However, I think that this has gotten into this bond proceeding because of the close similarity between him being on parole and the alleged offense. Now, you know, I gave you a copy of the statements that were taken, that were given to me by the prosecution. And as I read those statements, I read them and I handed them to you because I wanted you to see really how this issue developed. It's our position that irrespective of what may or may not have occurred, when the officer York's attention was drawn to this gentleman, Mr. Fulton, and he found out that he had a criminal history involving a sexual offense, then all of a sudden, this thing took on a different proportion. It took on a life of its own. Now, I gave you the statements that Officer York collected, because if you look at the statements, you'll see that there's a gross amount of difference between what the actual witnesses purportedly told the investigating officer. We went from touching on the waist to rubbing the rump in Officer York's statement. But now, when the actual witness and the actual victim, there's nothing in the actual victim's statement. Now, I listened to my good friend, Solicitor Warren Anderson yesterday when he was talking about third-degree sexual contact with a minor. And Judge, now maybe I just don't understand it. Maybe I've been doing this too long or something. But a sexual battery is required in order to have a third degree or to successfully prosecute. And I just don't see, and the statute spells out what a sexual battery is. Now, ordinarily, Judge, we don't get into this kind of discovery at a bond hearing. Of course, I'm glad for it, because if this case should survive a preliminary hearing and come to court, I'll have all of this wonderful information that we have for discovery purposes, but I don't think that this thing will see the light of day. Now, there is no allegation sufficient to constitute a sexual battery. And if there's not, then I'm wondering what in the world, talking to somebody, asking them to dance, I don't care what kind of history you got. I don't care if you're Jack the Ripper. That in and of itself does not constitute a criminal offense. And as far as I can see, that's all on a good day that the actual victims, or the victim and her mother, has said that Mr. Fulton did. Now, Your Honor, there are two reasons why I'm kind of skeptical about this whole situation. There's no question, and I've had some opportunity to talk to some witnesses myself, but there's no question that whenever this incident occurred, whatever occurred, Mr. Fulton said he asked the young lady to dance. I mean, he never saw her, he didn't know. At this event, he had all kinds of people out there. But the mother and her child, they resumed dancing and carrying on, and this was after they spoke to Mr. York. And just as if nothing had happened. I mean, they weren't distraught or put out or anything like that. They went on and had a good time. There's one other thing to consider. This was an event that was designed for alumni. And I must say, because of my own personal knowledge, starting with graduates of King Street Senior High School, starting in 1971. And it just happened that that was my first year, and that's what I was doing there. But it was for alumni, not children. So, I mean, as far as who Mr. Fulton would anticipate that might be there, or who was actually there, Judge, I would submit this was a public gathering for grown people, and not children. That's what it was for. But now, be that as it may, the children issue has gotten injected into it because of what he's charged with. But Your Honor, again, I have to go back to, and I don't want to beat a dead horse, back to the issue regarding bond. That is, whether he's a danger to the community or a flight risk. Not a flight risk. He had an electric monitoring device on his leg at the time that this occurred. I guess probation part of the rule put it on there. They took it off when he was arrested. Your Honor, to say that he's a danger to the community simply because he has a prior conviction for an offense involving sexual conduct. I just don't know, in all fairness, that makes somebody a danger to the community. Unless you add in whatever else you want to add into concerning how people make. And I'd be interested in knowing how this thing got from. There's no question that somebody said, well, he asked her to dance. He said that himself. And now, he went from asking her to dance to asking her to go with him somewhere. Where's he going to go? He's only got one vehicle, and his wife and sister sitting down in that vehicle. So, I mean, so you got asking her to dance, becoming asking her to go somewhere. But even if you ask her to go somewhere, that's not a violation of the law. That's just added on to give more strength to the allegation that he is some kind of danger to the community. But y'all, we will submit that all things being equal, this man, he did his time for what he did, and I say he did it because he pled guilty to it. But as far as denying him bond because of what I see on these pieces of paper here, and from the witnesses, which wouldn't survive any kind of cross-examination. They're all inconsistent, and at the most, the actual eyewitnesses said nothing more than they started off by saying he touched her on the waist. That's what the eyewitnesses say. And then somehow Officer York got into rubbing it behind and all kind of whatever. But that's on the issue, the substantive issue of whether or not the offense. But y'all, we would submit that he's not a danger to the community, he's not a flight risk, and he's entitled to a PR bond. Thank you, Judge.
All right, Mr. Anderson.
Your Honor, I respectfully disagree with Mr. Barr's argument that the parole conditions aren't relevant to this hearing. It shows the court that you will ignore the order's legal requirements. And what a bond is a legal requirement to behave. So they're asking for legal requirements to modify his behavior. At the same time asking to ignore the fact that he doesn't pay attention to it. He signed those documents saying he wouldn't be invested, that he wouldn't have contact with children. And then he is at this reunion. He approaches a 15-year-old girl. He's only been out of prison for criminal sexual conduct in the first week or 16 days. He touches the child and tries to take the child to a secondary location. And then approaches the child when she's with her mother and still tries to get the child away from her mother. That is incredibly dangerous behavior. We think that it showcases that he has no respect for orders from the court or for the legal system or for the law. We think that it shows that he is a danger to this community. There's a significant chance that he will reoffend and be dangerous to children specifically. Your Honor, lastly, we just ask the court to consider that if he is going to ignore the fact that he has a GPS, he's going to ignore the fact that he signed these documents, he's not going to listen to whatever bond you put in place to keep him a bond. We ask you respectfully to deny his motion for bond and move him to the case.
Judge, I would just simply ask the solicitor to point specifically to some condition in his release whereby he agreed not to go to a public function, which there is no notice that children would be there. And of course, at any public function, you would ordinarily anticipate the possibility that somebody under the age of 18 would be there. But in this case, we're dealing with alumni of high school. And these are the people that are invited, and these are the people that are supposed to be there. One of which he was. I mean, they were shaking hands and hugging and doing all kinds of things with graduates of King Street Senior High School. And quite frankly, I don't know the young lady that supposedly, from what I understand, she was moving around pretty good at this function. And I don't know if she looked like a minor or what. Of course, now I'm not saying that he's not responsible to exercise some discretion regarding whether she may or may not be under age 18. But the simple fact of the matter is, I don't think, based on what I understand, she was acting like he was a child. But all he did, from what I understand, was to find out whether she wanted to dance. If she didn't want to dance, then the mama got involved. But Your Honor, again, if the probation department decides to file a warrant, they're going to have to tell what proof that he violated parole. And that's where the facts comes in. And if they prove that he violated the parole, then that's a separate issue. He could be brought in for parole violation. But as it relates to this issue of bond, the simply suggested, well, we think he ignored the conditions of parole, therefore we think that's a basis for you to deny him. I ain't never heard nothing like that. That's ludicrous. That would have absolutely nothing to do with his status as it relates to bond. It may have something to do with a subsequent prosecution for parole violation, but not at this hearing to simply suggest, well, it seemed like he disobeyed what his condition of bond was. When the issue of whether he disobeyed, that's the very issue that's in contention. It's a factual matter that would have to be decided.
So why did he have an ankle monitor on?
The board ordered that he wear a monitoring device for 6 months.
And what's the purpose of that?
Judge, that's the one that we leave up to the board and make that decision and tell us that, you know, we're to put a device on, put the device on for the amount of time they say he's to wear.
It's not tied in with the curfew.
No, sir.
Not just the
Yes, sir. The other thing, Judge, is if he were to have a device on him for a Jesse's Law offense, then he could wear that device for life until some judge took it off.
And concerning the offense that he got the 18-year sentence, was that here in Williamsburg County?
Yes, sir.
Yes, sir.
Do you have any information about that factual scenario? Do y'all have the file?
I have his file right here, Judge. Because the board does not release to us an indictment, I would have to go downstairs to the clerk's office and get the indictment. What I do have is the victim impact statement from the victim. That's about as much information as the facts that I would have. The other information I would have to pull into the clerk's office. Actually, I do have the indictment here. And it doesn't give a whole lot of information.
The victim said that she was walking with her mom and a man came up to her and said, "Hey," and gave me a handshake. He asked me, did I know him? And I said, no. He told me, but I don't know anyone. I still don't know him. He asked, could I drive him home? I said, no, I'm 15. I can't drive. He was hugging me with one arm behind my back. He asked, could I go talk with him? But I don't know who he was, so I said I was going to tell my mom. I told my mom about the man, and then a little later, the man came and told my mom that he wanted me to go talk with him. My mom asked, what did he want? And the man did not say what. He only kept saying he wanted me to come with him. And that's the victim's statement. So I have a number of concerns about this matter. Primarily, whether Mr. Fulton be a sexually violent predator. Sexually violent predator is defined in our law as a person who's been convicted of a sexually violent offense and suffers a mental abnormality or personality disorder that makes the person likely to engage in acts of sexual violence if not confined in a secure facility. So we have Mr. Fulton, who was sentenced to 18 years in prison, a negotiated sentence, and in 2006, and he stayed in prison until 18 days, 16 days before this incident. When he's released from prison, he signs the notice of sexual offender registry that includes all these conditions, including not being around any children under the age of 18, not going around to any gatherings or any place where anyone, or within 1,000 feet of any area where a person under 18 might be, including schools, etc. And Mr. Fulton, and I don't know if he went through the sexually violent predator protocol or whether or not he was assessed as to whether or not he might be a sexually violent predator, but my responsibility is to ensure that, to the extent I can, that the community is protected from people who might offend or are likely to offend, and we know two things about Mr. Fulton. He's at a place where he was not supposed to be, and he's bothering a 15-year-old child, and he just got released from being in prison for 18 years. So I'm denying bond.
You know, with all due respect, can I read one thing to the court?
Yes, sir.
The law as it relates to third-degree criminal sexual conduct states that a person is guilty of criminal sexual conduct in the third degree if the actor engages in a sexual battle with a victim, and if any one or more of the following circumstances are proved. The circumstances are that the actor used force or coercion to accomplish a sexual battery in the absence of aggravating circumstances, or the actor knows or has reason to know that the victim is mentally defective, mentally incapacitated, physically helpless, and aggravating force and or aggravating coercion is not used to accomplish the sexual battery. Now, the sexual battery judge is defined in our law as sexual battery means sexual intercourse, convenience, fellatio, intercourse, any intrusion, however slight, of a person, part of a person's body, or an object into the genital or anal opening of another person, except when such intrusion is accomplished by medically recognized treatment and diagnosis. On its face, the warrant does not pass the smell test. And I realize that I'm not, this is not a preliminary hearing, I'm not asking you to dismiss for lack of probable cause. But Judge, I just, when the offense, he's not charged with bad behavior, accident, somebody that he doesn't know that turned out to be a child. He's not charged with accident a child. Now, of course, he says he asked a young lady to dance. Apparently, the business of going with him someplace, like I said, I don't know how to, but they have to make judge. That's what the law in South Carolina says constitute third-degree sexual conduct. And they have not even alleged, this man has been arrested on something that shouldn't have even been arrested for. I guess bad behavior is the most that they can say he did. Thank you, Judge.
Mr. Anderson, you want to respond?
Absolutely, Your Honor. The officers are charged in criminal sexual conduct in the third degree. The state plans on indicting him in criminal sexual conduct with a minor in the third degree, which envisions lewd lascivious touching above the clothing of the body parts of the man, with an intent to arouse, I can't remember the words, it's to arouse lust or passion in one person or the other. We plan on indicting him for that offense next grand jury.
All right. My concern is Mr. seems to be a danger to the community based on what he demonstrated on that occasion, and I'm not going to be a part of releasing him and some other child comes up being victimized. And so that's my basis for my decision.
Thank you.
All right.
Thank you, Judge.
This is Christian News TY. I'm Tony Conyers. Is there any newsworthy events in Williamsburg County? We will get them to you as soon as possible. If not, you can follow us on Christian News TY Facebook. You can follow us on YouTube, and you can follow us on our website.